Okay, so good morning. As we continue through Gittin, we are on Daf Tet. We are at the two dots. And let's just remind ourselves where we are. And specifically, let me share my screen. Here we go. So in the opening Mishnah of Masechet Gittin, we noted that if one brings a get inside Israel, then you don't need to say that it was written and signed before you, because as the Mishnah points out, the witnesses are going to be there. So, and this highlights the fact that even though Rabbah and Rabbah have a disagreement about whether or not it's about Lishma or witnesses being present, everybody agrees that on some level, it's also about the witnesses being present. And it's just Rabbah also says that it's about Lishma. And so that's a story. And so now the question is, what does it mean? And the Gemara says that in such a situation, okay, so I am bringing a get for Shlomo to give to Sarah, and I'm doing it all within the land of Israel, and I don't need to say that it was signed and it was written and signed in front of me. And so since I didn't say that, now Shlomo comes and says, hey, that isn't me. I didn't write this get. This is a get for, maybe it's a get for some other Shlomo, but it's not me. So then the Mishnah said that we need to bring the witnesses. We need to get the witnesses that are on the get. So now I already gave us the answer, but the question is we only said that somebody complains about the get. We didn't say who it was. And so now the Gemara is going to identify who it was. So im yesh alav orerin, right? If there is a complainant or are complainants about the get, yiskayim bechosma, the get will be established by its signatures. And again, this is at the first two dots, 14th line of dot tet amal. And so so that was a quote from our Mishnah. And now we explain, arar kama, how many people are complaining? Ilema arachad, if you want to say it's just one complainant. So then, v'ha'amar Rabbi Yochanan, divrei hakol ein arar pachot mishnayim. Well, 1 second, we have a general rule that when it comes to complaints about documents and somebody saying that a document is invalid, it is not sufficient to have one complaint. You need to have two people say that the document's not valid in order to undo it. The Ella Arar Tarti. So you so you may have to say, so then actually it's got to be two people that have complained. Well, 1 second, in that situation, now when you bring the two witnesses that validate the contract, Treyu Trainin, you've got a 2 versus 2 situation. And in a 2 versus 2 situation, my chazat to samchach ahani, samach ahani. How do you know that you rely on the second one that are confirming the contract? Maybe we should rely on the first set that are saying that the contract was not a valid contract. So how do we determine which group is going to be believed? Ella R Deval. Nice haircut, Mark. So we must be talking about where the husband is the complainant about the validity of the get. And so what is our situation? Our situation is I brought a get within the land of Israel from one person, from Shlomo to Sarah, and now Shlomo comes and complains. Well, then when Stan and Charlie were the signatories on the contract, on the get, we can bring in Charlie and Stan. They testify that in fact the contract, that it is their signatures, that the contract was in fact valid, that it was in fact Shlomo who was writing it for Sarah, and in fact is a good divorce decree, and the woman will be considered divorced. So that's a story. So now nice hat. All right, so now I know. So now we are up to the next Mishnah, and the next Mishnah addresses a situation. We talked about this over the course of the first days of the Gemara, but what happens if the messenger bringing the get from outside Israel cannot say that he witnessed the writing and the signing? Now, what in the world does it mean that he cannot say? Does it mean that he didn't see it and he didn't, and that's why? No, that's what we're going to find out that it does not mean that he didn't see it. But let's take a look and we'll see what the Mishnah says. Hamevi get Medina Sayam. If you bring a get from overseas, and the person is unable to say that it was signed and it was written and signed in front of me. If there are other witnesses that are on the document, you can still have a valid contract by confirming it through the signers. And the same thing is true. Yes, oh, absolutely, we're gonna have Rashi. And the same thing is true with both two kinds of contracts, not only a divorce contract, but in those days there was slavery. And if you free your slave, that contract also could be validated in this way. And in both of those cases, we say that bringing a contract to Eretz Yisrael or from Eretz Yisrael, the same rule applies. And the fact that you need to say that it was written in front of me and it was signed in front of me, that statement is both true for a woman's divorce document called the get, and for an emancipation document called a shicharurei avadim. Okay, so now the question is, so first we're going to clarify the first situation that we just talked about in the Mishnah, and then we're going to clarify the number of other situations in which we say that a divorce decree and a emancipation document are equivalent. Because again, we gave one way, but there are others. And in fact, it's implied in the Mishnah that there are others because we say ze achat min haderachim. Well, how many others? Not surprisingly, it's a machlokas, and we will see that in our Gemara. So let's begin by our analysis. Oh, but before we do that, let's do a Tosos here, because Tosos asks the following question. If we take a look at the second to last Tosos, it's a really good Tosos. So we are on Tet Amud Aleph. We just learned the Mishnah, and the Mishnah again said that if you documents for a get for a woman and a shichrurei avadim, an emancipation document for a slave, freeing a slave, those are equivalent in that both of them, when they are brought from outside of Eretz Yisrael to Eretz Yisrael or from Eretz Yisrael to outside of Eretz Yisrael, they're going to need the person taking them to say that b'fanei nechtav b'fanei nechtav, that was written in front of me and it was signed in front of me. And now the Tosos, in the second to last Tosos on Tet Amud Aleph, asks a great question. Shavu l'molech l'maybe. They're equivalent when it comes to bringing out and taking in. V'im tomar bishlama ba'isha habi mashum iguna. Well, we understand why we want to be lenient and allow one witness to be the bringer of the document and to say when he gets to the other land that it was b'fanei nechtam, and it will be a valid get, because we don't want women to be stuck in an unmarriageable position where they are separated from their husband and not able to marry somebody. About the eved, what kind of igun is there? What kind of oppression is there in that situation? If you want to say that, well, maybe because of his uncertain status at this moment, he now cannot marry a free woman or a slave woman. Lo litve hai shliach le'aved get zeh. Why not just say that the shliach can't do this job? And if you say that the shliach can't do this job, shehevim medina sayam, when he brings it from overseas, and then below yaser b'shivcha, he won't be prohibited to a slave woman, because a slave man is allowed to marry a slave woman. All right. So as a result, it's not just about being unable to get married. But v'yesh lomar, so Tosos points out two important qualifications in connection with a slave, especially a Jewish slave. One, meaning a slave of a Jew, who is considered subject to all of the mitzvot of the Torah other than time-bound mitzvot. That it is considered igun. The fact that he's not allowed to marry a free woman. Meaning, if you restrict someone's marriageability, then you are on some level creating a sense of igun for them. And in addition, you're creating a situation where this person is not fully obligated in all of the mitzvot because he is patur from mitzvot hashesha zman grama. So as a result, that's why this is considered a case of igun. And so as a result, we do want to, even though on the one hand, there's a general prohibition of freeing a slave. On the other hand, we want to facilitate the freeing of slaves because it creates additional Jews and it enhances their ability to marry the people that they want. All right, so now that we've explained that and we've clarified why we have the same rule, easing the process of divorce and easing the process of freeing a slave. Now let's go to the Gemara and we'll clarify what does it mean that the witness who brought this, that the agent who brought the messenger, I should say, who brought the get is unable to say it was signed, it was written and signed in front of me. So ma'enu yachol omar, what does it mean that he's not able to say? If you want to say, and the implication is the Gemara understands in the first instance that we're talking about a situation where he's physically unable to say. And so maybe he is a deaf mute. And so as a result, he's not able to speak. Well, one second, that such a person is not able to even bring a get. V'hatanan, we're going to see in a Mishnah on Kaf Gimel Amud Aleph, so basically 2 weeks from today, Kol Ksherim Lahevi as a get, Chutz Mishcherish Shota V'Katan. Anybody can bring a get except for a deaf mute, somebody who is not mentally capable, specifically, really does not have a sense of value of things and the like, and therefore is considered insane, or a minor. Those all three cannot bring the one who brings a get. So Amar of Yosef, here's what we're talking about. Rav Yosef explains the get was given to the person when he was still fully able and fully capable. Below his biklomar and he became a deaf mute at the time that he was supposed to say the statement. So until he said the statement, when he was given it, he was a valid messenger. And so as a result, everything was fine. But then when he gave it, so now he's no longer, and now he's supposed to speak, he's no longer able to speak. Okay. And since he had the ability when he was received the get as the messenger, we're going to say it's a valid contract, and it's just about whether or not we can prove, we would just need to prove that the two witnesses are valid. So, okay, so that is the situation. We've explained what it means that he cannot say. It does not mean that he didn't actually see it. It means that he just lost the ability to speak. Okay, so now our Mishnah mentioned that the obligation of the messenger to say that the document was written and signed in front of him applies equally to a get and to emancipation documents, and that this was one of the ways in which these two types of documents are equivalent. So now the Gemara explores the other ways that they are equivalent, quoting a brisa. So let's take a look at the brisa, and the brisa has two parts. First is the Tanakama, and then Rabbi Meir. So what does the Tanakama say? Tana Rabbanan. There are three ways that a get and an emancipation document are the same. One, as we noted in our Mishnah, when it comes to bringing taking a get out of Eretz Yisrael or bringing a get into Eretz Yisrael, they are both the witness, the agent, the messenger has to say b'fanei nechtav u'b'fanei nechtam. It has to be written in front of me. It was written in front of me, and it was signed in my presence. And if that happens, then it's a valid contract. Whether that contract is a get, a divorce decree, or a shechrurei avadim, or freeing a slave, in both situations, that will be a valid contract. B'chol get sheyesh alav aid kuti pasul. And then every get, and here when we say get, we don't just mean a divorce document, but any kind of contract. We actually don't even mean a get at all, because what are the next words? That when it comes to any kind of contract, here we're using get in the term as any kind of document. If you use a kuti as your witness, a kuti, I'll tell you in a moment is what a kuti is. If you use a kuti as a witness, he is invalid, not a good witness, except for if in fact it's a divorce document or freeing a slave, then he is a good witness. And we will talk more about this on Daf Yud, i.e. tomorrow. But let's take a look. But here they have a very nice, tomorrow it's an hour before Mincha. So I think Mincha is sometime around 7:45, 7:50. So probably about 6:50 is when we'll have Daf Yomi tomorrow, 6:50 p.m. And we'll have it with Ellie, God willing, probably in the second floor Beit Midrash. But let's hear what ArtScroll has a very nice summary of the Kutim. And so let's give that summary here. So the summary is that the Kutim was a group of people from different lands, including Kuta, and they were brought by the king of Assyria. So when the king of Assyria exiled the 10 tribes, so then they brought, the king brought in these individuals in their stead. And so when they came to the land, so God sent lions to attack them because they didn't believe in God, and they were not the people who were supposed to be there. And so as a result, they were taught to fear Hashem, and therefore they became essentially, and they converted to Judaism in part as a result of this danger. And so the question is, so that we have a dispute about whether or not this conversion was considered a valid conversion. Did they actually convert as a result of the lions, and therefore it's they were just afraid, and it's not a good conversion? Or after the lions were done with, then they converted and it was a valid conversion? And so there's a machlokas about whether or not this is a good conversion. So now this brisa is going to follow the view that they are considered converts. And the question is are they considered reliable? Are they, did they believe in God? Do they totally believe in the Torah? Because what they ended up doing, like the Samaritans that followed them, that they ended up believing only in the written Torah, not in the oral Torah. And so as a result, we don't generally trust them. But we will see, again, God willing, on tomorrow's daf, greater detail about the situation with Kutim, and that in fact, when it comes to a get Gittin nashim, a get for a woman, or a shechrurei avadim, or a document to free a slave, in those situations, we will accept them as witnesses. Okay.
About that. Professor Stephen Fine edited this book about the Samaritans.
Okay.
Which is really worthwhile reading. They are not accepted as Jews. They do not consider themselves as Jews.
Yes, well, those are the later Samaritans, essentially of Jesus's time and the time of the Gemara and Mishnah.
And today.
And today, yeah, absolutely.
There are fewer than 1,000 of them, but they store this. I actually met one.
Oh, wow. Yeah, and they still go to Har Grizim.
They go to Har Grizim. They actually now live on Har Grizim. They moved there recently, and in Cologne, and they do a Korban Pesach every year.
Yep, absolutely.
And they welcome visitors to that. Yep. And next year will actually be probably a big turnout to watch that, because their Pesach is not going to be in the same time as ours is.
Okay.
Our calendar. It's going to be off by a month next year.
Because they have, one of us is having a leap month that the other one is not a bear.
Yeah, they actually declare new moon still. But the interesting thing about that is they're not talking about Sadukim, who also did not believe in the oral law, and that they are they're so if the Samaritans are not accepted, Kal v'chomer the Sadukim, and today that actually has a practical application with the Karaites who don't accept the oral law,
Yeah.
and potentially even the Reform movement, which doesn't accept the oral law, over whether they're divorced or accepted. And Rabbi Abraham ben Harambam held that we do accept the documents of the Karaites, and there are some who don't accept him, although I don't know how you can overrule Rishon when there's not another Rishon. But that's actually a big deal today because there are tens of thousands of Karaites in Israel today.
Okay. Well, I
And
was
how
not
to-
aware that
how
there were
to-
that many carrots around. But
Not to mention the hundreds of thousands of Ethiopians who either never accepted or did not have the oral law. So what about and Rabbi Avadia Yosef ruled that they are full Jews and we accept their divorce documents.
wow. Well, that certainly would be consistent with this ruling that even a kuti get would be valid. And of course, one can understand that we want to try and that when it comes to the extent that we can argue that they're, from a biblical standpoint, they are Jews, well, then it makes sense to treat them as Jews with respect to this, even if in general we will rabbinically try to separate ourselves from them to protect our own tradition. So it makes a lot of sense that we treat all these categories in a similar fashion, but the kutim are sort of the original, or one of the original. Obviously, there's
the original people who didn't accept the oral law. Yeah.
So that's the story. All right. So that is item number 2. So again, we have 3 items that we're going to have on our list. Item number 1 is when the contract is brought from outside of the land or into the land or from the land of Israel. What we're talking about a divorce contract or a contract to free a slave. So it's not a duration of time. As soon as the document is given, the woman is allowed to marry somebody else, and the slave is a free person and able to own his own property and things of that sort. Okay, but so we have the 3 we are saying the 3 ways that a get and a shechrur avodim are similar. Number one is the requirement to say it was b'fanei nechtam. Number 2 is with respect to kutim, and number 3 v'kol ashtaros. As we turn to Tedem Abet, v'kol ashtaros ha'olam ba'arkos shel ovdei kochavim. When it comes to general contracts, one is allowed to use a court if it was processed by a non-Jewish court. When it comes to a contract, if I write you a contract, Mark, that says that I'm going to build a house for you, and I have it signed, even though I signed it with, we signed it with the non-Jewish witnesses, that is a valid contract and it is enforceable, and I would have to do that. But if we were to have a get or a shechrur avodim or to free a slave, then when those witnesses are not Jewish, or those or is being confirmed in a non-Jewish court, in those situations, the document is not valid. So again, we have 3 different ways that get and emancipation documents are similar. 1, b'fanei nechtam. 2, kutim, and 3, non-Jewish courts and witnesses. Okay.
So an interesting thing there's an assumption that it is permissible to free a slave here.
Yes, I mentioned that before, that it's not completely clear that this all is potentially violating the prohibition of freeing a slave. So you're absolutely right.
And an interesting thing, back when the United States faced slavery, in some of the states where, in some states, it was actually not possible to free a slave under secular law. So here you have the possibility that under halakha you could, but it wouldn't take effect under secular law.
Well, no, because it wouldn't matter that it doesn't take effect under secular law, because secular law is not considered to be applicable when it comes to freeing a slave. Meaning we don't observe secular law. This is an area like a get. You cannot just get divorced in Jewish religion. Getting a divorce is not sufficient to be divorced. You need to, you need to actually give a get.
Right.
Only,
But the problem is, if you issue a writ of manumission to an enslaved person in colonial Virginia until the 1780s, you under secular law would still be required to provide full support for that enslaved person, because he's still being enslaved under secular law, and someone else could actually capture that slave. And if you don't want him, he would be re-enslaved. It was
wow.
really a horrible situation.
Yeah, well, that all is true, but from a halachic standpoint, if you were being able to get that relationship enforced in a court of Jewish law, you would not be responsible for that. But you're absolutely right. That may not be, from a practical standpoint, possible in the pre-1780s Virginia. But all right. So now, so now we have, that was the three opinions according to the Tanna Kama. Divrei Rebbe Meir Ba'arba. But according to Rebbe Meir, there are actually four. And what's the fourth one? Ha'omer tain get zel ishti ushtar shicharur zel abdi ratza laxor b'shneim yaxor. Divrei Rebbe Meir. Rebbe Meir says that there's a fourth category. If I give Stan as my agent a divorce decree or a document to free a slave, and before he gives it to the person, either to my wife or to the slave, I say, you know what? I changed my mind. According to Rebbe Meir, in both situations, I'm able to change my mind. And this is based on the principle that we say, only with respect to something that is fully good. And because we say that a divorce is not necessarily fully good for the woman because she's no longer going to get support, and according to Rabbi Meir, it's not necessarily fully good for the slave because, again, there, as you noted, Charlie, just 2 seconds ago, there's you're going to lose the obligation to support that slave. Well, in that situation, it's not necessarily good, and so as a result, Rabbi Meir says in those two situations you can retract. So that's another similarity that exists with respect to this. These two documents that does not exist with respect to other documents. So now the Gemara wonders. Bishlam ala Rabbanan, it makes sense according to the rabbis that we said a number, Minyan and L'Mu'utei Had Rebbe Meir. We say 3 because we're trying to say that they disagree with Rebbe Meir. And by the way, with respect to the rabbis would say when it comes to a divorce, yes, the man can retract until it actually gets to the wife. But when it comes to the freeing of the slave, as soon as that contract to free the slave is given to the messenger, the slave goes free. So that's a way so they are not similar according to the rabbis. So and again, that's the point. That's why they say 3, because they're excluding Rebbe Meir. El Rebbe Meir min yanid l'me'utei mai. What is he coming to exclude by saying 4? Well, the Gemara answers, L'me'utei hadatanya. It's another case that we see in the following brisa, where we'll see that, in fact, we distinguish between slave documents, an emancipation document for a slave, and a get. All right, and what's the situation? If you have witnesses, and I'm going to explain this according to Rashi, if we have witnesses that do not know how to sign their name, Mikarin lahen niyar chalak. We can carve their names into the document, into the blank part of the document. And then they could fill in that etch with ink. So Amar Rabban Gamliel ben Shimon Amar Rabban Shimon ben Gamliel, B'medvar Memurim. When are we talking about that we will allow this kind of witness to actually write their, get the assistance in writing their name? B'gidei nashim, when it comes to freeing, when divorcing a wife. But abal shecharuri avadim ushar shekol shtaros im yodin likros lavachtom chosmin v'im lav ein chosmin. The bottom line is when it comes to other kinds of documents, they need to be able to read the document and sign their names. And if not, they cannot sign. So 1 second. Kriyaman Ducharshme. I don't understand. At the very end, we've been talking about the ability to write. And you suddenly now mention the ability to read. Who said anything about it? Well, Chasuri Mechsara, the Bryce is missing some words. This is what it's teaching. When it comes to witnesses who don't know how to read, obviously they saw the writing of the divorce and so they are witnesses to validate the divorce document. But they don't know what they're signing. So you're allowed to read it for them and then have them sign. So then, Koran Lifneim B'chosmin. And if they don't know how to sign, well, then we can etch it for them. And again, this only applies by a get and not for other kinds of documents. And so what Rabbi Meir, and when he says that there are 4, he's saying there are 4 because this one is not a way in which a get and a shichur avadim would be the same. That in fact, an emancipation document does not have this rule. And so that's why he says 4, because it's not 5. The Suleka, well, 1 second. You're telling me that there are only these 3 or 4 different ways that they're similar, but there are not other similarities or equivalencies. V'ha'ika, there are plenty of other equivalencies. Let's take a look. Ha'omer tenu get zela ishti ushtar shecharur v'tzela avdi umeit lo yitna lachar misa. Well, when it comes to a regular, but tenu mana leplonit umeit yitnu lachar misa. When it comes to writing a check to somebody, and I give you the check to Stan, and then God forbid I were to pass away, so Stan is allowed to give the check to whoever I told him to give it to, because I've already written the check. It's as if it could be delivered. But if I were to give Stan a divorce decree or an emancipation document, then and God forbid were to die, well, then that would be a situation where he would not give the document to the intended recipient, because my relationship with that recipient is already over because I've unfortunately passed away. So kikitani milsa delay say bishtaros. So in second, so the point is that we're teaching these points that only apply to that when we teach these similarities between a Gittin and emancipation documents, we're teaching situations where the similarity is only between a get and an emancipation document. But milsa de isi bishtaros lokatani. But something that could apply to other documents as well, we're not going to learn that. And how could this situation where the giver passes away apply to other forms of documents? Deshalach Ravin Mishmei to Rabbi Abahu, because we have the following message that was sent from Ravin to Rabbi Abahu. Hayu Yodim Sheshalach Rabbi Elazar Lagola Mishum Rabbeinu. We know that Rabbi Elazar sent the following message to the Galus in order to teach, in the name of our teacher. That's referring to Rav. So Shchiv Meira Sha'amar Kisvu Utenu Manalaploni. If somebody is very sick, they're on their deathbed, and they write and they say to somebody that the person says, Stan, I want you to write this document and to give a mana to John Doe. But umate, and now this person who was on his deathbed died before Stan was able to write the contract. Ein kozvin v'nosnin. So if the contract were already written, Stan would go ahead and write it, and give it. But when it's not written, we do not write it and we do not give the money. So Shema lo gamar la haknos ela b'shtar, because maybe he only wanted this to be given in the form of a contract. Ve'ein shtar la achar misa, and you can't write a new contract after the person has died. So as a result, that's why we didn't give this similarity between a get. So although it is true that a get and an emancipation document can't be given to their intended recipient after the giver is dead, but we can, but because that also can apply to certain situations for contracts. We did not want to mention that similarity. Well, one second, we're going to have another similarity. What about the fact that a get and a emancipation document both have to be written specifically for the people involved? So Bishlam al Rabba, it makes sense according to Rabba, Hainu Moluch maybe, right? Remember, the whole concept of Rabba was that when we say that you need to say B'fanei Nektam, it's about Lishma. So as a result, Rabba, it can work. El Rav Yosef, El Rabba, Kasha. But for Rabba, who says that it's all about needing the witnesses, that's going to be a problem. Why didn't we say that Lishma is a reason? V'su bein l'Rava, bein l'Rava, and for both of them, ha'ika mechubar. We have a rule when it comes to a get, and although we haven't seen the source of this rule yet in the Masechet, we've referenced this rule a few times, and that is both a divorce document and a document, an emancipation document, both need to be separated from the ground when they're written. You can't take a big leaf of that is currently attached to the ground and write the document and then separate it from the document and give it as either a get or an emancipation document. That doesn't work. So why isn't that a similarity that's mentioned? And so the Gemara answers, Ki Katani, when is it that we are teaching about Psula D'Rabbanan? The situations are all rabbinic disqualifications, things that make the get or the emancipation document disqualified from a rabbinic perspective. Again, meaning if the person doesn't say B'fanei Nektam, so then that's going to disqualify the get or the emancipation document only from a rabbinic perspective. From a biblical perspective, it would be valid. Number two, what was the second one? The second one is the kuti situation. So apparently, what we're saying right now is that really a kuti, the fact that a kuti is an invalid witness on other documents, is only rabbinic disqualification. And finally, the third situation is the other documents processed in the court of law. Again, even though these documents might have been processed in a court of non-Jewish law, maybe they're only disqualified for a get and an emancipation document only rabbinically and not biblically. So 1 second, we're going to ask about that last situation. Well, 1 second, when it comes to divorce decrees and emancipation documents, having them processed by a non-Jewish court makes them invalid biblically. The katani, and yet we included it in our brisa. So be'edei mesira, we're talking about a situation where there are valid witnesses to the giving of the get. And so as a result, because there are valid witnesses to the giving of the get, and we're talking about the Ucha Rebbe Elazar, and we're like Rebbe Elazar, because what does Rebbe Elazar say? Da Amar Edi Mesira Karti. It is not the witnesses that are written on the document that cause a divorce to be valid. It's rather the witnesses that see the document being literally given to the woman. That's what makes the document valid. And so as a result, that is why we're going to say that when we go to a non-Jewish court, it is really a valid witness, a valid divorce decree biblically, and it's only because we had valid witnesses to the giving of the get. And so as a result, it's only rabbinically that we're going to say that since you went to the non-Jewish court to enforce it, we're going to say that it's not a valid get. Well, 1 second, what about the end of our Mishnah, which we haven't read the end of our Mishnah, because the end of our Mishnah has been separated with this Gemara, and the end of the Mishnah, which we'll begin with, God willing, or we'll touch on tomorrow, because it's on Daf Yud Amud Bet. So what does it say there? Rabbi Shimon Omer, Af Elu Ksherim. It's not tomorrow, it's going to be tomorrow afternoon. So even tomorrow, an hour before Mincha, about 6:50. So Af Elu Ksherim. These two are going to be kosher. V'amar Rebbe Zera, meaning that a get and an emancipation document processed by an idolatrous court, by a non-Jewish court, they are going to be valid. And V'amar Rabbi Zera, and Rabbi Zera is going to explain, Yarad Rabbi Shimon, l'shita so shel Rabbi Elazar. It's clearly Rabbi Shimon agrees with Rabbi Elazar. Damar Adi Masira get karti, because he believes that it's the Adi Masira, the witnesses to the giving over of the get, that are the ones that make it a valid get. Miklal de Tana Kama Savarlo. That implies that our Tana, the one who is in our Mishnah, would disagree with that. So how can we say that that our Mishnah is consistent with Rebbe Elazar when we see that later Rabbi Shimon agrees with Rebbe Elazar, implying that our Tana disagrees with Rebbe Elazar? So the Gemara answers as we turn to Yudam and Aleph, Ika Benayu, Shemos Muvhakim. Really, both of them agree with Rebbe Elazar. And Rashi puts it nicely. So let's take a look at the Rashi, top Rashi and Yud Amud Aleph, because we haven't done a Rashi today. So Kolomer Tanakama B'shita say the Rebbe Elazar kai, right? The Tanakama agrees with Rebbe Elazar. And it's only a rabbinic prohibition that that makes this get or emancipation document invalid because you went to a non-Jewish court. Dilma asi lemismach achasumin, because maybe you'll come to rely on the non-Jewish witnesses who have signed on the document. Ulamosro b'fneihem, and maybe you'll think that you could actually give the document in front of those two witnesses. V'asa Rabbi Shimon l'meimar, and what does Rabbi Shimon come to say? Im shemos muvhakim, if the names that are on the document are characteristic of non-Jewish names, that it's clear. For example, their names are Chris and Jesus. She'ein Yisrael Nikran Ba'osan Shemos, where you don't have people who are named with that name who are Jewish. Lav Hana Mizuyef Mitocho. That's not going to be a problem on the document itself. Demoda Rebbe Elazar, that in that situation, Rebbe Elazar would agree to Kuli Alma Yade De'ovde Kochavim Heim, that he would say, everybody knows that these people aren't Jewish. Below Asi Lemismach Alayhu, below Edi Masira. And people will know that you can't rely on them without valid, good witnesses for the giving of the get. Okay. So now that so what have we done? So we've explained how we can still answer. So at the moment, we have still answered that our situation, that the reason that we have not mentioned Lishma or the fact that it is the documents need to be attached ground, we've not mentioned both of those because those are biblical requirements, and we are only talking about situations of rabbinic requirements for a get or a emancipation document. But now we're going to raise another similarity. We've raised 3 similarities already. Again, the first similarity was the ability. The first similarity was the post-death similarity. The second similarity was Lishma, and the third additional similarity was the fact that it has to be disconnected from the ground. And we've explained that, yes, there are those additional similarities, but all 3 of them involve biblical situations, not rabbinic situations. And so that's why they weren't mentioned in the Brisa. But when second, the point that Rabbi Meir made, that you can retract it, that is a biblical point. The Gittin, and yet we're going to find out. We're trying to explain it. We'll get to it in a moment. The Gittin, and yet our Brisa taught it. So we therefore have to come up with a totally new explanation, because we need to again explain how our items in our list are unique and different from the items that are also similarities, right? So we have a number of additional similarities, and we wanted to say that ours were all rabbinic and those were all biblical. that doesn't work because chazara is also a biblical concept. Ella ki kitani, what do we list in our brisa? Milsa delasi b'kedushin, things that only apply to a divorce. So the whole concept of kutim being valid is only for a divorce or for emancipation. The whole concept of going to a non-Jewish court only true for a divorce and emancipation document, not for a marriage. And the whole situation with having to say b'fanei nektam, also true only with respect to a divorce and a emancipation document, and not true with respect to a marriage. But milsa de isa kedushin lo katani. But when it comes to something that could apply to a marriage, well, then we are not going to learn it. Well, 1 second, chazara gufa ise b'kedushin. This item that we just caused our problem, that we require you to change your answer, that also applies to kedushin. We can say that if somebody sends a messenger and then says, you know what, messenger, don't actually do the delivery, we can say that it's talking about that situation. Well, no, because b'shlichus bal karcha, when we say that we're talking about a situation of marriage, we're talking about a situation where once the person does it, there's no other force that's involved. And when it comes to a divorce, that's the case, because we're talking about before the Gzeira of Rabbeinu Gershom, after who says that and that means that because it's before that Gzeira, a woman was allowed to be divorced against her will. It's only in the time of Rabbeinu Gershom that we created a Gzeira that says that a woman could not be divorced against her will. And so as a result, that's the kind of messenger that we are talking about. The begerishin isa begadushin lesa. That when it comes to divorce, then it's not going to. There's no ability for her to stop it. But when it comes to marriage, so then she has a right to not be married if she doesn't want to. And so as a result, even though the messenger, there's a messenger, it doesn't mean that it automatically happens. So what have we said? So let's go through it with an overview to conclude, and then with that we will say good jontif and we'll be done. So we have the 3 or 4 ways that are listed in the brisa of similarities between divorce decrees and emancipation documents, and they are again requiring to say b'fanei nektam, the ability to use kutim, and the fact that you cannot enforce them in courts of non-Jewish law or have non-Jewish witnesses on them, and according to Rabbi Meir, it's the ability to retract. And why don't we list other things like lishma, like it needs to be separated from the ground, and like it needs to and the third one was that it only applies until the person's death? Well, the answer is that we are only listing things that apply only to divorce and not to marriage. And we are only talking about situations where the situation is that as soon as the thing happens, there's no power for the woman to reject or for the slave to reject. And so as a result, that is why these items are listed in our brisa, the 4 items, 3 for the rabbis, 1 that's added by Rabbi Meir, and none of the other items, even though there are more similarities. Now, I said earlier today that we're going to talk more about the kutim and why they are going to be considered a valid witness on a get or an emancipation document. But God willing, for that, you will need to stay tuned to tomorrow's daf. So I wish you all a Chag Sameach, and I look forward to our continuing to learn. Hold on, let me just stop the recording, and then
I have a question,
okay, sure, go ahead.
somewhat rhetorical. When we universally accepted the idea that women cannot be divorced against her will, does that change the halakha that we just learned here?
Which halacha are you thinking about? Meaning, it does the halacha. None of the halachot changed with respect to the ability. It was only the
About
relevance
the retraction.
the relevance of the ability to force a woman to accept the divorce was only used to explain why we listed certain items and not other items. It was not actually used, the ability to force a divorce was not actually used from a substantive legal perspective. It was only helping us qualify and which categories we were going to mention and which categories we were not going to mention. Does that make sense? So as a result, when you change the underlying facts, that would only adjust which items we would list in our brisa. It doesn't actually change the underlying facts. Obviously, the main fact being of the main change of the Gzeira is that, in fact, well, now we don't allow women to be divorced against their will. But
Right.
It doesn't change any of the laws that we were talking about today, because that rule was
Concerning retraction.
exactly. So
Okay.
what was that? Yeah, exactly. And so only with respect to retraction, and there it wasn't about the legal rule of retraction, it was about the categorization of retraction. Why is retraction considered one of the 4 items in our brisa and not one of the items that has been left out? So so I don't think it actually would change. The Rabbeinu Gershom wouldn't change any of the laws that we said today. Obviously, the main law and the most important thing that does change is that we don't divorce women today against their will.
Thanks.
All right. Have a Chag Sameach, a
Chag
wonderful
Sameach,
and you too. Look forward to continuing
Chag Sameach.
and a happy 49th day of the Omer.
Amen. Happy 49th day of the Omer. Yes.
Chag Sameach from Lakewood.
All right, enjoy.